Hey, my name is Kevin Peach. I am the founding attorney of NC Wills and Trust. If you've received this video, that means you are interested in estate planning. In this video, we are going to go over the five basic estate planning documents that I think everybody needs as part of their estate plan. Plus, we'll give a brief overview on probate and the difference between wills and trusts. Just a quick note on our firm. We are a triangle-based law firm. Specifically, our office is in Rollsville, North Carolina. We have clients all over the state, from Asheville to Fayetteville to Greenville to Wilson, kind of all over the place. So, no matter where you are, I think we can be of assistance to you. Uh, our main goal as a firm is to keep estate planning accessible and more affordable for all North Carolina families. In my experience at prominent triangle law firms, I found that most estate planning, specifically trust planning, is far too expensive for most clients. It kind of turns most people away right at the start. And I think people need to take advantage of estate planning, specifically planning with a trust, in order to utilize those benefits. I frankly think that everybody needs a trust, no matter what your economic status is. If you own anything, I think you need a trust. So let's go ahead and get into the slideshow. All right. Okay, here are the five basic estate planning documents that I mentioned. First is a will. A will is pretty simple. Everybody's heard that everybody needs a will, and yes, that's absolutely true. A will is a written expression of someone's intent on who gets their stuff whenever they pass away. I mean, it's pretty simple. I don't need to make it more complicated than that. I think a will is absolutely necessary for anybody who owns property. Frankly, because if you don't have a will, then there's going to be a lot of unintended consequences. For example, if you are married with children, if you pass away, your spouse is only entitled to a third to a half of your estate, depending on how many children that you have, and the children will receive the rest. So that can cause some obvious issues. So I think that's why it's important to have a will. Otherwise, having minor children, you need to name a guardian, things like that. So, uh, if you want your assets to go other than what's already in state law, which that is 99.9% of people, I think that you've got to have a will. The second document here is a power of attorney. You'll hear it referred to as a general power of attorney, a durable power of attorney. That is a financial power of attorney. So what that does is it gives your designated agent the ability to step into your shoes in a financial sense to make those financial decisions for you. Now, why that is important is towards the end, most of us are either going to get dementia, Alzheimer's, or frankly get so senile that we can't take care of our affairs. Or maybe there's a medical incident and we've had a stroke, we're in a vegetative state or non-responsive. Most of the time, once you get to that kind of level of incompetency, I said most of the time, every time, once you cross that threshold into legal incompetency, you cannot make those decisions for yourself. You can't sign off on documents. Nothing is enforceable that you do. You can't withdraw money from the bank. You can't sell a house. You can't refinance a house, things like that. So that's why it's absolutely critical to name a power of attorney, an agent, to be able to do those things for you. Usually that's a spouse or a trusted child or family friend, something like that. But remember, if you are using this, it's you're probably in pretty bad shape, and usually people need to sell things, transfer money, refinance a house, things like that in order to keep you up. So that's why that is so important. If you don't have one in place and you cross that threshold into legal incompetency, then your heirs or your loved ones are going to have to go through a guardianship petition in order to be able to move your assets around like that. And a guardianship petition is essentially a lawsuit against you. You're going to have to hire an attorney, or they're going to have to hire an attorney to get that done. It's a long delay, court appearances, things like that. It costs thousands and thousands of dollars. So this is kind of an ounce of prevention type situation here. The third document here is a healthcare power of attorney. Healthcare power of attorney is just like a financial power of attorney, but it allows your healthcare agent to make healthcare decisions for you. You can give them as much power or as little power as you want to make those decisions. You can tell them they've got to listen to doctors. You can customize that as much as you want. Usually that's given to a spouse. A living will. A living will is basically the pull the plug document. So I don't think I've ever had a client that said, "Hey, keep me going as long as you can if I'm not going to recover." But that's what a living will is going to do. It says, "Look, if I'm in such rough shape that the attending physician says I'm going to die very, very soon, there is no reasonable chance for me to recover." The living will says, "Hey, doc, pull the plug on me." That's basically what it says. Don't keep me going. Give me something for the pain, but don't keep me going as long as you can. Let me go as soon as possible. HIPAA authorization. So that is the last of the five documents that every estate plan needs. HIPAA authorization allows anybody that you give given power of attorney to access your medical information. So you would think that giving somebody a healthcare power of attorney would entitle that person to access that information. No, that just allows them to make those decisions going forward, but it does not allow them to access your information from when you were admitted to the hospital to further on in the past. So that's important because if this is kicking in, that means again you're in rough shape. Your power of attorney is going to need to know what medication you've been on, what the dosages are, when's the last time you've been taking them, things like that. So that's what a HIPAA authorization is going to do. Hospitals and doctors are absolutely handcuffed by federal law from giving that information to anybody, no matter who it is, without an authorization like that. So that's why it's very important to have that. Well, you can still do it. Just I'm going to go back to that slide. So what makes us different as a law firm is we don't charge all that much to do these documents. A will, if you just need a will, we charge 275 for that. And we craft every document, we draft every document for each and every one of our clients to tailor to their individual needs. So it's not just I press a button and it spits this thing out. It's not you fill in the blank type thing like a LegalZoom or going to the credit union. This is drafted by me, a licensed North Carolina attorney. If you need power of attorney or any of these other documents, well, those are $100 each. So if you want all five, which is a will package, which is what almost everyone does, that is $500 per person. So it's a flat rate. You save a good amount of money doing it that way. So we don't like to hide the ball. I tell you our prices right up front. All right. So the thing with going down the will path of estate planning is there's some limitations to having a will. And what those limitations are is your heirs are going to have to go through probate to get legal title of your assets after you pass away. Probate is about a year to a year and a half long process. It is essentially your heirs have to inventory and report absolutely every single thing that you own to the county, to the state. Um, it's all public record, so anybody off the street can go online and pull this probate file, so they can see exactly what you owned, uh, what form it was in, how much was in those bank accounts. They can see everything, and further, they can see what your heirs inherited, what they inherited, where it's located, things like that. So people want to avoid probate for the publicity of it. I think the hassle is another important factor. I've probated tons of estates in my career, and I think I am an attorney. I am trained to do this. I think it's a massive hassle. I think most people aren't really suited to get it done, especially when they are grieving their parents or a child or a loved one. They need to focus on healing rather than going through this year to year and a half long process, and it's full of red tape, start and go type situation. And further, it is very, very costly. Probate costs. Studies say it costs between 3 to 10% of the value of your estate. So do the math, that adds up really, really quickly. So that kind of begs the question, how do you get around probate? Now, the only two ways to get around probate is one, don't own anything, so be completely broke. I don't think anybody wants that. Number two, you can set up a trust. So what is a trust? So there's two types of trust. One is a revocable trust. One is an irrevocable trust. A revocable trust is what most people end up doing, and simply a revocable trust helps avoid, not helps avoid probate. It avoids probate completely. So you avoid the publicity, you avoid the 3 to 10% of your estate being wasted, paid to the county, to executors, to attorneys, to uh, the newspaper for your notice to creditors, things like that. It makes inheritance instant. So that's important because remember, I said probate takes about a year to a year and a half to get done. In the meantime, your heirs are stuck paying your mortgage, paying the property taxes, paying HOA, uh, paying insurance, paying everything to keep your home up, keeping it out of foreclosure before they can sell it. And they can't sell it until probate's done. So that might saddle them with bills that they can't afford. They probably have families of their own or financial struggles of their own. So essentially, forming a trust keeps it out of probate. Uh, there's no legwork. You were kind of taking most of the legwork on that would have to have been done at probate, minus a lot of toil. You were doing that yourself when you set up the trust. Essentially, forming a trust is like taking something from your left hand and moving it to your right hand. With a revocable trust, you can still put assets into the trust whenever you want, pull them out whenever you want, dissolve the trust whenever you want. You are in complete control over the trust assets. In order to set up that trust properly, all you have to do is number one, have an attorney draft the trust. Number two, transfer your assets into the trust. So with real estate, that's simple as doing a deed into the trust. We handle that as part of our trust packages. With bank accounts, things like that, it's simply changing the title on the bank account from you individually to the name of the trust. It's not difficult. We give a checklist and we can walk you through that after you've set up your trust. So that is the main benefit of a revocable trust. I have lots more information on my website and would be happy to talk you through this on the phone, Zoom, in person, whatever you want to do. The other type of trust is an irrevocable trust. Now, the main benefits of an irrevocable trust is number one, you avoid probate. It's the same thing as a revocable trust. Number two, it makes you absolutely judgment proof. So, essentially, when you form an irrevocable trust, you are putting all of your assets, or you're putting whatever assets that you want to make judgment proof or uncollectible from anyone, including the government. You're putting that into the trust. Now, that trust is actually going to be the true owner of that property. And the reason I say that is because it's irrevocable. You can't change the terms of the trust. And further, if you were trying to set up an irrevocable trust, the only way to do that is to name a child or a family friend or a trust company or an attorney as the trustee of that trust. That means that you are giving up access to those funds. You have to ask the trustee to disperse those funds to you. But the benefit is, look, since you don't actually own that property, if somebody ended up suing you and getting a judgment against you, they couldn't collect against you because you don't own anything. In North Carolina, there's no wage garnishment, so it makes you bulletproof in lawsuits. Also, with an irrevocable trust, and this is why most people do an irrevocable trust, is it helps you qualify for Medicaid long-term government assistance. So usually, whenever you qualify for that, if you own any assets, you're going to pay a massive penalty. And upon your death, your heirs are the government is going to claw back the money that they've essentially given you, keeping you going by taking that from your estate. They're going to take the entire estate. Your heirs won't inherit anything. Uh, if you set up an irrevocable trust, name a child as the trustee, put at least your house into the trust, but maybe other assets. Essentially, after a 5 year period, after you've made that transfer, those assets are no longer considered your property, according to the government. So you qualify for Medicaid instantly, and your trustee can help disperse that money to you to keep you going. help you live a much better quality of life while you're in long-term government care. And then also makes it so your heirs actually inherit something. So that's a crash course on probate, on wills, on trusts. Let me go over the pricing on trusts. Trusts, we charge one right now as of May of 2025, and I don't know what my prices will be in the future, but right now we charge $1,000 for a revocable trust. If you want a trust package, which includes the trust, a will, a power of attorney, a healthcare power of attorney, a living will, a HIPAA authorization, and the deed to get your home into the trust. We charge $1,400 per person for that. If you want an irrevocable trust, add on $500, so it'd be $1,500 just for the trust agreement. A trust package will be $1,900. So, yeah, like I said, we don't like to hide the ball. We tell you all these right off the bat, just so you know what you're getting into. And frankly, most firms in the triangle will charge you about $5,000 to $6,000 per trust. So we charge a lot less than most firms do. And the reason why we do that is, frankly, we think it is the best way to do estate planning. So if you have any questions, feel free to contact us. I'm going to put our contact information on the screen. There it is there. So that's our website, willsandtrustnc.com. You can email us at plan@willsandtrustnc.com. Our address is here. Again, we're in Rollsville. That's our phone number there. So, yeah, it was a pleasure being able to share this information with you. Please don't hesitate to reach out if you need any information. If you'd like to set up a consultation, those are free as long as it's about estate planning. If you want to talk to me about your cousin's criminal case going on, well, I'm not a criminal attorney, but I'd have to charge you for that. But anyway, it's been a pleasure. I appreciate it. Thank you very much. All right, bye bye.